My name is Henry Lindpere. I'm a senior immigration counsel here at Manifest Law. I've been working on a wide variety of different business immigration cases, a lot of EB-1A, O-1, and EB-2 NIW, and also a range of other business cases from E-1, E-2 treaty visas to L-1s, H-1Bs, TNs, you name it. Also some family-based cases, but as soon as I started my career, it kind of started moving towards the business immigration. Today's event is about the anonymous submissions that we've received. Before I jump into those, just a quick legal disclaimer here that people have submitted these submissions voluntarily and anonymously, and I will be offering as an information purposes my opinion, and it's not considered as legal advice. I'm not your attorney specifically. The law in this area is very, very nuanced, so even small changes in fact can change the outcome or the analysis from an attorney's perspective. So we do not have a attorney-client relationship, and if you need specific legal advice to your situation, my recommendation would be to visit www.manifestlaw.com. You can request a consultation, and our intake team will connect with you quickly and look at your profile and get you on the calendar to talk to an experienced immigration attorney as quickly as possible. Okay, later we're going to have a Q&A as well, but right now we're going to start with some of these evaluations. Now, before I give the specific examples here, I'll just do a very, very quick overview of the different visa categories or case types that we're going to be talking about here today. So we're going to be covering things related to the EB-1A, the O-1, and the EB-2 NIW. Now, most of you already know this probably. The EB-1A is the one that sort of everybody wants, or that's the best, and that's because it's the hardest to get, but it also has the shortest wait list, especially important for people who are born in India, for example, where the EB-2 category is highly, highly backlogged. EB-1A is intended for people who are among the, let's say, top 10% in their specialty. And what that means is you will be evaluated in comparison to other people who do similar things that you do. So, for example, if your career prospect or your career plan is to be an academic researcher, then getting a PhD is just a starting point, not the end point for an EB-1A, because most researchers in academia have that level of education. It's all about what you've accomplished or achieved, and that means they want hard proof of how good are you and what you've already done, how you've impacted your field. The evidence that they're looking for, I'm sure you've seen it, so I'm not going to go over that in detail in the intro, is that either a major award such as a Nobel Prize or an Oscar or something like that, and then in the alternative, there's that 10 categories of evidence, and you need to have at least 3 of those. And if you have at least 3 of those, then USCIS will evaluate your profile on the final merits analysis, which is a subjective analysis from the officer thinking about, do you really have national or international acclaim? Are you really one of the top people in your areas of expertise? The O-1 is like a temporary equivalent of the EB-1. The evidence criteria is nearly identical. However, in practice, it's actually a little bit easier to get an O-1 because USCIS is just more flexible with the O and more forgiving, whereas with the EB-1, they are very, very strict. So for the EB-1, they are looking for a longer track record of top-notch achievements, and for an O-1, the track record has to be maybe a little bit shorter. So even for the recent breakthroughs, basically can secure an O-1 approval. The EB-2 NIW is the one that's considered easier than an EB-1, but it's not a linear comparison. It's really very, very important for the NIW to be focused on what it is that you're specifically doing. And it's really good for people whose work has some strategic importance for the United States. But not everybody with a master's degree is a good candidate for the NIW. For example, the strongest cases still are related to academic research, defense, public health, public policy, and anything that's connected with nonprofits or government work. So if you have connections with the government, then they can support your case. That carries a lot of weight for the NIW. Whereas being a startup founder of a social media platform or an e-commerce platform is generally not a good NIW, because besides the economic benefits for the country, there's not really a strong argument for societal benefit from your business. Whereas with the research, it's much easier to make a claim that your work will benefit the country or society more generally. Now, I'm going to jump into some of these examples that we've received from people, and I'm going to give you my assessment on what I think are their strengths or potential things for improvement. And it's not a very detailed information that I have on these, because we wanted to make it anonymous, and if I have too much nuanced detail about a case, then it might get too easy for the listeners also to figure out who we're actually talking about. The first submission here is a professional that is working in the field of biotechnology. They have 4 years of experience in their field, 4 peer-reviewed publications, and they've won a Global Health Research Award. They also say they have funding for their current work, and they are claiming, or they are self-reporting, let's say, that they would have published material about their work, original contributions of major significance, judging the work of others, and a national or international award. Now, I could be wrong on this, of course, and like I said, I don't know that much detail because this is very superficial level of information. But based on what I'm seeing here, my first instinct would be this is going to be a good EB-2 NIW case, but at least not yet a strong one for an EB-1A. The reasons would be that 4 peer-reviewed publications is enough to meet the scholarly articles criterion for the EB-1. But when we're looking at EB-1, you have to look at the final merits, which is right now the battleground for EB-1A cases. So USCIS is not obligated to approve the case, even if you have 3 or 4 criteria. So we're seeing even people with 4 or 5 criteria acknowledged being issued RFEs for final merits, where USCIS says that even though you have all of these criteria met, based on all of the evidence you've submitted, we don't see that you are really a big shot, right? That they're looking for some level of fame or notoriety in your field. And looking at these details I've been provided with, 4 years of experience and some award and 4 papers, that sounds to me like somebody who is fairly early in their career, and that leads me to believe that on the final merits they would have a big uphill battle for EB-1. Now, for EB-1, scholarly articles and judging the work of others, those are the most objective and easy ones to tick the boxes on. Original contributions of major significance, this is a really tricky one because it's the hardest criteria to meet for EB-1 because it's the most subjective. For that criteria, USCIS is looking at 2 keywords: original and major significance. So the work has to be something original that you created that never existed before, such as peer-reviewed papers or an invention, a patent, a new software, a new vaccine, if we're talking about biotechnology, things like that. But the second thing that they cling to is that major significance keyword. And that means that they want to see impact, not what the impact could be in the future, but what can you prove that has already happened. So if you are one of the creators of the COVID vaccine, and you can show that you created it in record time, and here's how it helped slow down the pandemic, that's EB-1 material. But if you are a researcher in a lab and you are working on some new mRNA vaccines, but nothing has actually gone out to market yet or saved any lives yet, then USCIS would not consider that yet as a majorly significant contribution. And then the final part here is that national or international awards, that they say they've got a Global Health Research Award. For EB-1 purposes, the source of the award is critical information. USCIS will always want to know who issued this award, what are the rules for getting the award, how many candidates were there, who were the judges making the decision on it, and who are some examples of past winners of it. It's very common. I see people in master's and PhD programs who start working on their own EB-1s because they read that evidence criteria and they send me their DIY drafts, and I see university scholarship awards being listed as awards for the EB-1 criteria. University awards generally don't meet that standard for EB-1 nationally or internationally recognized awards, even though they do show some level of prestige or recognition. So if this award is coming from, let's say, the World Health Organization or something like, that's a whole different story, right? So whether that award is coming from inside a company, inside a university, whether it's open to just the students at the university or whether it's open to all scientists around the world and they can apply, that's going to make a lot of difference in terms of how much weight does this one award carry. So if this was something World Health Organization award, then I would say, okay, now we're getting more closer to the EB-1 territory in terms of the profile qualifications. But based on this initial analysis, I would say that this is probably not a good EB-1A yet, but you could have a case for an EB-2 NIW. The key point for an NIW is going to be the proposed endeavor, and that means what are you planning to do in the future? So if you already are working on government-funded research, you have funding from NIH, NSF, DARPA, different government sources like that, and you have a detailed plan of what it is that you plan to keep researching. So let's say it's in the vaccines field and you explain what is your particular expertise in a specific, you know, category of science and what kind of vaccines are you best equipped to be developing, showing what's your past track record and then how that's positioned you to keep making scientific contributions in this field, and why is that important for the United States, whether you're working on vaccines for people or vaccines for specific animals that are very important for the farm economy or agricultural sector. All of that, that story fits well with the NIW. So I think the NIW for this one would be a good starting point, potentially moving from there to maybe an O-1 and an EB-1A later, depending on what's your current status and how long are you allowed to be staying here. Because another key thing for the NIW is that you don't get a green card as soon as you get an approval. You have to get the petition approval, and then it's going to take you several years before you can actually apply for the green card because of the backlog. So I would say whether you're currently on a student visa or OPT or maybe already on a J or F or J or H1B, I would consider the NIW here and then keep working on the profile and getting more and more accomplishments over time to build towards an EB-1A later if that's necessary. Okay, second scenario, we have a senior engineering manager who is working in the gaming industry. They have 15 years of experience. They've won an award, published 4 articles, and they've had some speaking engagement at a gaming event or conference. And when we asked them what categories of evidence do they believe they would be able to meet, they said original contributions, judging, leading critical role, awards, memberships, and high salary. Just looking at the number of these, that does sound like to me that there might be a good fit for an EB-1. But let's go into some of these categories in more detail to determine what would help to either boost the profile or what would be the weaknesses here. So for judging, I don't have much details here on what kind of judging work they've done, but good examples of judging for an EB-1 would be doing peer reviews for scholarly paper or publications, also peer reviews for conference publications, right? So if you are reviewing something for IEEE for one of their conferences coming up, that counts as judging. Also any kind of hackathons. So if there's a hackathon specifically for gaming industry, that would be a cool one to add to a profile like this. In general, like I said, judging is one of those easier categories because it's very objective standard. You just have to be able to show that you were invited to judge and that you did in fact judge some kind of a competition or review the work of others. And there's not that much that USCIS can argue about, except for when the judging event is something very rudimentary level, like you're judging a competition for high school students or something. Then they can say, okay, this is not really judging your peers because these are very beginner level people who aren't already professionals in their field. And ideally, the competition would be or thing that you're judging is something with already professionals in the field, not just students. 4 published articles. Now, again, like I said before, that's a good starting point for it. The more the merrier, of course. You will get the criteria box ticked if you have 4 articles, but because the final merits are final standard for EB-1, then even if you already have those articles, if possible, I would continue to keep working on new ideas, drafts, and continuously adding more articles or publications to your record. Now, there is also a speaking engagement at a gaming event. This is good for final merits. Being a keynote speaker, conference speaker, being on any kind of industry roundtable is not something that fits any of those evidence criteria in the initial analysis for EB-1, but it is exactly the type of evidence that USCIS is looking for if you're saying that you're an expert or one of the leaders in your field, because it's the type of thing that they think an expert should be doing. They expect you to be the one on stage teaching others how to do something, not being in the seats taking notes from somebody else, right? So they expect you to be in that level of authority. What I am currently recommending to anybody who is seeking an EB-1 is to get out of the office and go and do as much things publicly as humanly possible, because there are a lot of experts, a lot of really talented people that I talk to every week who have 10, 20 years of experience, but they've just been doing their office work, producing incredible work for their employers, but outside of their employer, nobody really knows who they are. And this is the part of the national acclaim or international acclaim that USCIS is looking for, is they want to see that companies or people outside of your immediate colleagues and employers know who you are because of how good you are, that you've established some level of fame or a positive reputation as a subject matter expert in your field. What else was here? Oh, original contributions. Again, like I mentioned, this is the hardest criteria to meet for EB-1. So number 1, it has to be original, and number 2, it has to be of major significance. In a gaming industry context, what I could think of as being original contribution of major significance would be if you are the one that develops one of those gaming engines that's then being used by multiple other developers to create, or studios to create, build their game on top of that engine, because that shows that your work is being copied by others. Or it could be maybe you creating one game, and if that then turns into one of those cult-like games that defines a genre, but just because you have, let's say, an app that's a popular game, that doesn't necessarily mean that USCIS is going to say it's of agree that it's of major significance, because they want to see what is the impact of your work in the field, not just your impact for one specific company. So a good way to think of it is like this. If you work in a company and your biggest accomplishments, professionally speaking, are things that improve that company, then that goes under leading or critical role. If your biggest contributions surpass the company and are something that are really rippling through the entire industry, that's when you probably have a good argument for original contributions of major significance. Which brings us to that leading or critical role part in this scenario. A role can either be leading or critical or both. Leading role basically means what is your position in the corporate structure? Are you in a position of a leader, meaning that you have responsibilities and authority to make decisions on your own? Do you have people reporting to you? That means things like here it's senior engineering manager. So that means I'm guessing they have people reporting to them. Depending on how big that team is that reports to them, that could be a leading role. And critical role is really something that's about not necessarily how high you are in the hierarchy, but specifically what are your contributions to the company and how is what you've done professionally of high importance for the business. So if you are an engineer at AWS and you build something that's the very core architecture for every client that's relying on AWS, and it's the cornerstone of the whole cloud system and the data centers and everything, then you can say you have a critical role, even if your title isn't sounding like very high up or impressive. Now, in this scenario, we also have the person talking about awards and memberships, but we don't have any information about what they've actually been accepted to or awarded. Like I said before, awards key is what is the criteria for winning the award, who is the one issuing it, and who are the past winners, things like that. For memberships, USCIS always wants to know what is the rules for becoming a member, and the harder that is, the more likely it is that fits under there. So for example, for IETE to become a fellow, you just need to show that you have certain number of years of experience and you're working in the field in high level position, but it doesn't say that you need to be amazing or that you have to have some contributions. Whereas if you go to um, IEEE, in order to become a fellow, you have to be nominated by others, and you can only become a fellow if you have demonstrated significant contributions in your field. So one of those would be a yes, and the first one would be a no, as in not difficult enough to meet that membership requirement. Okay, we're almost running out of time here, so we're gonna take some questions if anybody has any questions. If you can think of any questions you wanted to ask, please go ahead and write it in the chat, and I will take a look. Okay, buddy here is Kim is writing, I am the founder with an independent director, offer letter. All right, so if you're the sole founder of a US company, then first of all, what I would really do in a situation like that is I would use an agent rather than having even somebody else sign. But I would add another layer of protection and I would use an agent. So an agent is a third party who is basically preparing and signing the forms for your case. And then in that agent filing, I would include the offer letter or signed contract. And then I would have that contract signed as you as the beneficiary, and then this independent director who is signing on behalf of the company. And the relationship with your company is something like um, a resolution from the company. Let's say you own the stocks and you're the sole owner, then it would be a resolution from you assigning this independent director to be one of the member directors on the board, or a resolution that you are assigning them the position of the company secretary or company treasurer or president or something like that. And that would show that they have and that resolution should state that they have authority to sign on behalf of the company. And that's how you can make that connection there. But to add another layer, I would say using an agent would be even better than just having your own company be the direct petitioner, because USCIS has been getting a little bit more strict on the O-1 case. And in their recent policy updates, I believe there was a mention that they kind of reiterated that, remember, self-petitioning is not allowed. We have to be creative about how we structure that filing. Differences in criteria between the O-1 and EB-1. So if you're looking at the O-1A and the EB-1A, then they are basically identical, but O-1 has 7, I think, and EB-1 has 10, because some of those EB-1A criteria, additional ones, are related to the performing arts and exhibitions. And so the O-1 has other subcategories. So there's an O-1A for business, science, athletics, and then there's an O-1B for arts, and then there's another O-1B for movies and television. And those criteria don't match exactly with the EB-1A. So, by far the easiest one to do an O-1 for is basically somebody who is in scientific research, because if you read those criteria, they're very much worded as, oh, okay, if somebody is a professor, then they're going to have a much easier time meeting at least 3, 4, 5. Whereas if somebody is in the arts, then meeting those in the EB-1A is going to be harder. Whereas at least in the O-1B, they have specific criteria for being in a leading role for a production, like, which could be a theater play or something like that. And that doesn't really match with EB-1A. So there's more options on the O-1, and that's why it's often easier to do than an EB-1A for somebody. And also because the standard is just a little bit different. Okay, let's see what else we have time for here. Salary criteria for O-1 and EB-1 is you want to be in the top 10% of people with a similar job as yours. And usually we use both public and private wage data. So if you have an SOC code on your H-1B, for example, then you can pull Bureau of Labor Statistics data on what is the 90th percentile wage rate for somebody in your job. And then you can also use private sources like Glassdoor, ZipRecruiter, and so on. Now, unfortunately, I don't have any more time. We're running over here. Okay, I'll do the last one here. A difference between entrepreneur parole and EB-1. The entrepreneur parole is not a permanent residence. It's a temporary thing that just authorizes you to stay in the United States. But EB-1 is a permanent residency to get a green card, which eventually can lead to citizenship if that's what you're looking for. The entrepreneur parole, that's really a very niche thing that I see most attorneys avoiding, because there's very little benefits from that, really. Honestly, I would rather work on a O-1 or something else instead of focusing on the entrepreneur parole. Okay, thank you so much, everybody, for your time, for joining us today. I hope it was informative. Like I said before, if you do have specific questions or would like more specific legal advice that's helpful for your situation, then visit us. You can email us at help@manifestlaw.com or visit manifestlaw.com, and we have a lot of information available on our website, and connect with our intake team, get you scheduled for a consultation. And if you mention this webinar, then there's also a discount for any legal fees that we'd be charging. So hope to see you, some of you, in a consultation soon. And thank you very much for your time. Have a good day.